Welcome, friends. This is a third part of the question and answer series on Chapter 2 of Companies Act 2013, Incorporation of Company and Matters Incidental thereto. Let's begin. Our first question is on a note on alteration of memorandum. The memorandum of a company is a foundational document that outlines the company's objectives, registered office, and capital structure, among other details. The Companies Act 2013 provides a framework for altering the memorandum, ensuring that any changes are properly authorized and documented. Key provisions: General provisions for alteration, special resolution. To alter the provisions of its memorandum, a company must pass a special resolution complying with the procedure specified in the Act. Approval for name change. Changes in the company's name require approval from the central government, except when the change is a result of a converting between the different types of companies. Example, from private to public. Change in the company name. Approval and registration. Any alteration to the company's name must be approved by the central government, except in the specific cases. Upon approval, the registrar will update the register with the new name and issue a fresh certificate of incorporation. Certificate of incorporation. The change is complete and effective only after receiving the new certificate of incorporation. Change in registered office. State transfer. Central government approval. Alteration involving moving the registered office from one state to another requires central government approval. The application must be filled in a prescribed manner and the government has 60 days to process it. Consent of creditors. The government will ensure that the company has the consent of creditors, debenture holders, or has made adequate provisions for discharging its debts and obligations. Filling requirements. After approval, the company must file a certified copy of the central government's order with the registrar of both the old and new states. The registrar of the new state will issue a fresh certificate of incorporation. Change in object of the company. Special resolution and disclosure. If a company with unutilized public money changes its object, it must pass a special resolution. The details of this resolution must be published in newspapers and on the company's website. Dissenting shareholders must be provided an opportunity to exit. Registrar's role. The registrar will register the alteration concerning the object of the company and certify it within 30 days of the receiving the special resolution. Effectiveness of alteration. Registration requirement. No alteration of the memorandum has any effect until it has been registered in accordance with the provisions of the Act. Provisions specific to companies limited by guarantee. Profit sharing prohibition. In companies limited by guarantee and without share capital, any alteration of the memorandum that provides right to participate in divisible profit otherwise than as a member is void. Case law. Messrs. V.S. Dempo Company Limited versus Messrs. D.J. Malpani 2017. Facts of this case. In this case, the company sought to alter its memorandum to change its registered office from one state to another and to amend its objects. There was a dispute over whether the company had properly followed the procedural requirements and obtained the necessary approvals. Judgment of this case. The Bombay High Court emphasized the importance of a strict adherence to the statutory procedures for altering the memorandum. The court held that the company must obtain the requisite approval and ensure proper documentation and filing with the registrar. Failure to comply with these requirements would result in the alteration being deemed ineffective. Our next question is on a detailed note on alteration of articles of association. The Articles of Association of a company governs its internal management and administrative rules. The Companies Act 2013 provides a framework for altering the AOA, which can be crucial for adapting to new business conditions, changing regulations, or structuring the company. This section outlines the provisions for altering the AOA, including the conversion between the private and public company status. Key provisions: General provisions for alteration. Special resolution. A company can alter its AOA by passing a special resolution. This resolution must be passed in a general meeting with the required majority. Memorandum of Compliance. The alteration must comply with the conditions contained in the company's Memorandum of Association, if any. Conversion between private and public companies. Private to public. A private company can alter its AOA to remove the restrictions and limitations that apply to a private companies under the Act. This alteration will convert it into a public company. Public to private. A public company seeking to convert into a private company must obtain approval from the tribunal. This is necessary to ensure that the conversion does not adversely affect the right of the stakeholders or violate regulatory requirements. Filing and registration. Filing with registrar. After passing the special resolution, a copy of the altered AOA and, if applicable, a copy of the tribunal's order must be filed with the registrar within 15 days. The registrar will then register the alteration. Effectiveness of alteration. Once registered, the alteration is deemed valid as if it was a part of the original AOA from the outset. Special provisions for tribunal approval. Conversion approval. When converting a public company to a private company, tribunal approval is mandatory. The tribunal assesses the impact of the conversion on shareholders and other stakeholders before granting approval. Alteration of memorandum or articles to be noted in every copy. Every alteration made in the memorandum of articles of a company shall be noted in every copy of the memorandum of articles, as the case may be. If a company makes a default in complying with the provisions of the subsection 1, the company and every officer who is in default shall be liable to a penalty of 1,000 rupees for every copy of the memorandum articles issued without such alterations. Case laws. Rajasthan State Industrial Development and Investment Corporation Limited versus SK Day 2002. Fact of this case. The case involved the Rajasthan State Industrial Development and Investment Corporation Limited, which sought to convert from a public limited company to private limited company by altering its AOA. The tribunal's approval was necessary for the conversion. Judgment. Delhi High Court has emphasized the necessity of obtaining tribunal approval for converting a public company to a private company. The court held that without tribunal approval, the alteration would not be effective. The case highlighted the role of the tribunal in safeguarding the interests of the public shareholders and ensuring compliance with regulatory standards during such conversions. Next question is on a detailed note on a rectification of company's name. Section 16 of the Companies Act 2013 addresses the issue of rectifying a company's name if it is found to be either identical or too similar to the name of the existing company or a registered trademark. This ensures clarity in business names, avoiding confusion and protecting trademark rights. Key provisions. Identification of name conflicts. Subsection 1A. If a company, upon its initial registration or upon a change of name, is found to have a name that is identical to or too similar to an existing company's name, whether under this Act or any previous company law, the central government can direct the company to change its name. This direction is given to prevent any confusion or misrepresentation in the marketplace. The company is required to comply with this direction within 3 months by adopting an ordinary resolution to change its name. If a registered proprietor of a trademark under the Trademark Act 1999 find that the company's name is identical or too similar to their registered trademark, they can apply to the central government within 3 years of the company's registration or name change. The central government can then direct the company to change its name. The company must comply within 6 months of the receiving this direction. Procedure for changing name. When a company changes its name under this provision, it must notify the Register of Companies within 15 days. The notice must include the order from the central government, and the registrar will update the company's certificate of incorporation and memorandum to reflect the new name. Penalties for non-compliance. If a company fails to comply with the direction to change its name, it faces a fine of ₹1,000 for each day the default continues. Additionally, every officer in default can be fined between ₹5,000 and ₹1 lakh. Case law example. In the case of Amit Sharma versus Reserve Bank of India, the issue at hand involved the rectification of a company's name that was found to be too similar to an existing company's name. The court upheld the central government's directive for name change, emphasizing the importance of avoiding confusion among consumers and protecting established businesses. The court decision reinforced the application of Section 16, highlighting that such directives are crucial for maintaining clarity and legal integrity in the business environment. Our next question is on conversion of companies. Section 18 of the Companies Act 2013 deals with the process and implications of converting a company from one class to another under the Act. Under the Act, this provision allows companies to change their status, example, from private to public or vice versa, while ensuring continuity in operations and obligations. Key provisions: conversion process. A company registered under this Act may convert itself into another class of company by altering its memorandum and articles of association. This change must be made in accordance with the provision laid out in this chapter. For instance, a private company can be converted into a public company, or a public company can be converted into a private company, provided that the relevant legal requirements for such conversion are met. Registrar's role and issuance of certificate. Upon receiving an application for conversion, the registrar will ensure that all applicable provisions for the registration of the companies have been complied with. Once confirmed, the registrar will close the former registration and issue a new certificate of incorporation. This new certificate signifies the company's new class and status, but is essentially a continuation of the company's existence under its new classification. Continuity of debts and liabilities. The conversion of a company does not affect any existing debts, liabilities, obligations, or contracts incurred before the conversion. These remain enforceable as if the conversion had not taken place. This provision ensures that the company's legal and financial responsibilities continue seamlessly through the conversion process. Our next question is on a subsidiary company not to hold shares in its holding company. Short note. Section 19 of the Companies Act 2013 addresses the prohibition and exceptions related to the ownership of shares by a subsidiary company in its holding company. This section is designed to prevent conflicts of interest and maintain transparency in corporate governance. Key provisions: prohibition on shareholding. A subsidiary company is generally prohibited from holding shares in its holding company, whether directly or through nominees. This provision ensures that a company cannot have a financial stake in its own parent, thereby preventing potential conflict of interest and maintaining clear lines of accountability. Void allotment of transfer. Any allotment or transfer of shares from a holding company to its subsidiary is deemed void under this section. This means that such transactions will not be legally effective, reinforcing the prohibition on subsidiary shareholding in the holding company. Exceptions to the prohibition: a subsidiary company may hold shares in its holding company if it is acting as a legal representative of a deceased member of the holding company. In this case, the subsidiary is holding shares on behalf of an estate, not as an investor. The subsidiary can also hold shares if it is acting as a trustee. In this scenario, the shares are held in a fiduciary capacity rather than for investment purposes. If a company was a shareholder in the holding company before it became a subsidiary, it may retain its shares. However, it can only vote on those shares in the capacity of a legal representative or trustee as per the aforementioned provisions. Voting rights. Subsidiary companies holding shares in their holding company under the exceptions provided can only exercise voting right in respect of the share held as a legal representative or trustees. This ensures that the voting power of the subsidiary is restricted and does not lead to undue influence over the holding company's decisions. Application to companies limited by guarantee or unlimited companies. For holding companies that are not limited by shares, such as the companies limited by guarantee or unlimited companies, the term share is interpreted as interest of its members. This provision extends the prohibition to the forms of interest held by members in such entities, ensuring that the prohibition on holding shares is applied broadly across different types of companies. Thank you.